10, Tyson Patterson versus Melissa Toons.
All right, Mr. Ward, are you here on behalf of the plaintiff?
I am here on behalf of the plaintiff. I was appointed probably about 9 days ago, by the public defender's office. Actually, while I was on secured leave. But
okay. So you were appointed on the contempt issue?
I was court appointed on the contempt issue and only the contempt issue. That is correct.
All right. And Ms. Toon, looks like you're representing yourself. Is that correct?
Yes, Your Honor.
Okay. All right. So this matter is on for the motion of the defendant for contempt. Is that correct?
Yes, Your Honor. However, I'd like to motion for continuance for the contempt due to two of my witnesses didn't show up even for the motion for emergency. But I'd be willing to proceed with that, but not the contempt without the other witnesses.
What says the plaintiff, Mr. Ward, about the motion to continue?
I would respectfully object at this time. My client is here, present, ready to proceed. Even on the notice that I got, I'm here ready to proceed. I've had an opportunity to go through with this. We do have potential witnesses were it to come to a hearing. I will say that there's some other issues in the case that I don't want to get into necessarily, but there's some other people that have been called into court that I have some concerns as an officer of the court if they keep getting yo-yoed back into the court. And given the potential merits or lack of merits of the motion to ask for an order for criminal contempt in this case, I think it would be more appropriate to have it heard today, at least to the extent of her request for a court to enter an order.
What witnesses are you missing?
Law enforcement officers. Actually, I had two other witnesses today just for the emergency hearing, but it's going to take a lot longer than 3 hours. So we're not going to have enough time to even get into the contempt. As you see, it's 5 pages long. The motion for emergency custody is
let me address that then real quick, because as I was looking through the file, you filed a motion for emergency custody. That motion was denied. I consider that to be essentially now res judicata, so nothing for me to review.
Your Honor, at that time, the Children's Law Center was appointed due to their previous inclusions on the case. However, due to incidents that happened after, they've removed themselves off of the case. And I haven't seen or heard from my child since October 25th of 2020. In addition to, when I filed my motion at the last hearing, I attached a 50B that came from Guilford County that had been venue transferred to Forsyth. And for some reason, it did not exist in this courthouse. We were left without any protection, and it showed that Talia was physically assaulted. And I don't believe that the court has had a chance to look at that.
Well, that's a completely separate and distinct issue from your motion for emergency custody, and whether or not that's previously been heard by another judge, which I believe that it has.
I did mention it in the motion for emergency custody about the fraudulent actions, and I do have documents to support that. However, I am concerned that the detective that I subpoenaed, in addition to Mr. Patterson's, his probation officer that had just revoked him, they are very important witnesses, and I feel at a loss without my witnesses.
All right, so again, let me try to parse. These two things are separate in my mind. You got the contempt and you got the emergency custody. The emergency custody motion, again, that was heard and denied, and I don't think there's anything left for the court to review. Do you have any position on that, Mr. Ward? Are you not appointed?
I'm not appointed on it. I certainly have an opinion on it, but I'm not going to interfere with the court's judgment on that.
So that leaves us just with the contempt. What are you missing witnesses on your contempt? That's what you said you wanted the continuous with.
Yes, and actually there's more that had just recently came out as well. Documents that I was given last year from the hospital that were referred to a detective in Winston-Salem PD for an investigation for sexual abuse of a child that my child disclosed, had not investigated. I filed with Internal Affairs, and I've subpoenaed him here today, and he is not present.
How would that be contempt against Mr. Patterson?
I'm sorry?
How would that be contemptuous against Mr. Patterson?
It's just a part of it. If you want to go through the motion, it's a part of it. It's quite lengthy.
The motion is 5 pages long.
Yes.
I want to know what the names of the witnesses are that you claim that you need.
The names of the witnesses is MJ O'Reilly and David Doheg. But additionally, I knew that I would have finished today by 5, and it would need to be continued, and I really needed I have a whole list of witnesses that I would want for the contempt hearing.
For the contempt, not for the emergency
For
custody?
the contempt, yes. I mean, I wanted these witnesses that I've subpoenaed that you see there, that they've been served in addition to this gentleman, for the emergency custody motion, because it was never heard. It was just given to the Children's Law Center, then continued and continued. I've never been able to speak on it. Therefore, it's never even been addressed.
The emergency motion, which has a signed order denying defendant's motion for emergency custody signed by Judge Davis.
For the ex parte, but we've never had the 10-day hearing.
Well, the ex parte is even a better opportunity for you to be heard because the other side's not here. And if you couldn't satisfy the emergency at the ex parte stage, there's no way you're going to be able to satisfy it now.
And I apologize. At that time, I have since even gotten more information that I was unaware of, and that's why I feel it's very important for me to have witnesses here.
Okay, well, again, that motion is done. If you feel that there's a further need for a motion for emergency custody, I suppose you're free to file one, but this motion has been determined already by another district court judge, and I'm not going to overrule that district court judge. So the emergency custody is done. The motion for contempt is still pending. And again, I'm still trying, so that you mentioned two would appear to be officers.
One is a probation officer, one is a detective, that I did.
It sounds like the detective is not something that would be any kind of contemptuous act on the part of the plaintiff.
No, but there's been a lot of interference in investigations, and I have evidence of that as well, Your Honor.
It's not contemptuous either.
And I understand what you're saying. However, if I was given time to present my evidence and cross-examine my witnesses, you would understand why I need those witnesses here.
And, Your Honor, if I may, briefly, just on a procedural note, I have not, at any point either from the Public Defender's Office or from Ms. Toombs, received a subpoena for any witness in this case, including a subpoena for an individual that's present today. So I would just argue, at least at this point, that without in a civil case where I'm required to have notice of any witnesses that are coming in that are being subpoenaed, I would certainly raise issue with this litany of witnesses that would supposedly take this on to 5 p.m. or 8 p.m. or a multi-day hearing. I will say as well that at least the court file from my review of it, I do raise an issue, and I want to raise this again just because there is still the pending request for continuance in this case. My concern as a professional as well as a counsel for my client is that there is a history, and as you've noted in your order back from 2019, a history of both parties making accusations.
I'll give you a chance to respond, but
yes.
You let him finish.
And more recently, there have been a number of filings that have been made by Ms. Toombs that have been made, for want of a better word here, it seems like she's continuing to try to go after the same thing and relitigate issues that have already gone before the court. And I have some serious concerns in terms of malicious prosecution by Ms. Toombs. Now, I don't know if that's something the judge wants to, or Your Honor wants to address today, but at least part of my objection to her request to continuance is just the fact that if we take this with more time, more things are eventually going to get filed one way or another. More evidence will come out of the woodwork somewhere where there is a recent spate of cases and documents in the file where Ms. Toombs has, both here and in West Virginia, made allegations that were shown to have no merit even at the preliminary stages.
And I'd like to object to that as well. And Your Honor, at this point, I am motioning the court for you to recuse yourself from this case due to your previous inclusions in this case as well.
Why would that require me to recuse myself?
In the past, Mr. Patterson was held in criminal contempt and arrested. I was given custody. The question came up about abuse, and then he was given full custody. During that time, I located medical records to show she was abused and neglected the whole entire time. It's been hidden. She's been abused. I have photos.
Focus for a minute. My question is, why does my previous involvement require me to recuse myself?
Because of the order itself. It was basically violating my constitution and my civil rights. I should have objected to you hearing the case at that time due to Harold Eustache. and I should have asserted myself then, and I'm doing it now.
What constitutional rights did you say that I violated?
The rights for equal protection. The Children's Law Center came in and slandered me after we had a full report that showed that Talia was unsafe and he was unstable, inappropriate, and unhealthy. She then went into his custody and suffered more abuse. Therefore, it would be, something that you wouldn't be able to be impartial on.
I don't know if just because you disagree with my decision, that's a reason for me to have to recuse myself.
It's not just a disagreement, it's the fact that I had a relationship with someone you are close friends with that used to work for the district attorney's office.
He adamantly denies that.
Well, due to the last order, I am putting that on the record. I am filing for for you to recuse yourself. Just like in the past, I've had a lot of experiences here and I've never been heard. And I want the truth to prevail.
I've heard this case at least 3 times.
And that was years ago.
Opportunity to testify and ask questions of witnesses.
I was traumatized, I was abused and under coercive control, and I had no idea what was happening to my child. I was not able to properly defend myself or speak for myself, and at this point, due to the acts and the actions that have happened in this courthouse, it's seeming more and more strongly to me that I need to move the venue or bring somebody else in to hear this.
I think even the first time I heard this case, I granted you custody as a child.
And then she was given to him, and I barely had any custody, and now I haven't seen her in 8 months or heard from her.
And I think I made that clear in my last order as to why that is.
And those were false statements.
This is the primal example of a case where the individual hates the other party more than they care about.
It's not hating. I've been abused and raped and beaten and destroyed by this man for years. I have not one calls going back to 2012. I have evidence of domestic violence going back to 2012 right here. 911 calls. 25 911 calls.
Your Honor, if I may, these statements go, essentially, they're more evidentiary at this point. She's making unsworn statements here, and it looks like she's trying to...
considering them as evidence, but...
I have evidence to show my child was abused and neglected during the time after you've given him custody based on the fact that he made false statements in the court and it wasn't...
You claim to have that evidence in 2019?
No, I did not.
You claim to have that evidence in 2018, and you claim to have that evidence in 2018?
No, I did not. I found it last year.
Never appeared?
No, because nobody investigated the Children's Law Center because they want to create conflict for funding.
Okay. Well, the court is quite familiar with the Children's Law Center and rather thinks that they do excellent work.
They removed themselves out of this case.
Because of their casework? Or
it's not because of the casework.
Of the parties involved.
It's because an investigative reporter found 4 other mothers with the same judge dynamic that has harmed children. Okay. I found 4 other mothers. I have a support group of 1,000 women, and this is happening. Our children are being harmed, and I'm here to speak for my child.
All right. Well, I'll grant your motion to continue the contempt hearing. That will then resolve the recusal issue without me having to formally do that. I will ask, however, that at least, I would say at least 2 weeks before the next time this matter comes on for hearing, you provide Mr. Ward a complete copy of your witness list that you intend to call to testify at that contempt hearing.
Sure, yes. I mailed that in regular mail to Mr. Patterson's address. I'll make sure I get it to him.
Well, give it to Mr. Ward. Does she have your contact information, Mr. Ward, or can you provide it outside the court?
I can provide it outside the courtroom. I will also inform the court that I have a motion that I want to file, at least on the contempt motion, that'll have my contact information on there as well. But that's for another day.
Is 2 weeks sufficient?
Is 2 weeks okay for you?
I mean, not to set the hearing, but 2 weeks notice of the witnesses, is that sufficient for you then to
Absolutely.
Determine who it is and if there's anybody you want to talk to?
Absolutely.
All right, so Madam Clerk, can you propose a date to bring this back on the contempt? I'm going to file an order on the emergency custody. Again, this is essentially stating what I've stated, that motion has already been decided.
Even though it wasn't heard in a 10-day hearing, and I've never been heard on that motion. It's been continued every time. I've never even been able to speak on it or submit any evidence or speak to the court other than that short hearing before I was apprised of the documents that I have now. so it's never even been heard.
It was heard in front of Judge Davis.
But that was a 10-day hearing that I've never been given.
There's no need for a 10-day hearing if the motion was denied. The requirement for the 10-day hearing comes if he granted the motion ex parte, then you set it for 10 days so the other side can be noticed and come in and given an opportunity to be heard.
Well, he did
When it's
schedule another
denied,
hearing.
there's nothing to come back for that other party to be heard on.
He scheduled the next hearing, though, to be heard again because of all of the violence. For a reason, it needs to be heard.
Well, then your issue is with Mr. Davis, not
Your Honor, my understanding, at least obviously I wasn't there at the time, my understanding that it was rescheduled for the contempt that had also been filed around the same time.
It was a week later. It was only given a date so the Children's Law Center could be appointed, and due to their liability in the case and not their caseload, they removed themselves.
It says right in here in the order that based on the motion and testimony provided by the defendant, so clearly you had an opportunity to be heard. So I'll file that order, but we'll set a date for the contempt matter. What date?
Your Honor, how long should how long do you?
I would say at least a month so that she's got time to get her witnesses together that she wants to have present and then notify Mr. Ward of that.
I don't need a month.
Well, he's got 2 weeks after you provide the list. How you say document keeps coming forward.
I just hope my child survives them this time. I haven't seen her since October, and I have custody yet. Therefore, even though I haven't even seen or spoken to her, and I have evidence that she's been abused and neglected by a man who's breaking the law and on drugs and hurting her.
I have no.
He was just in jail for 2 months during this time. He just got revoked on probation. He's assaulted a mother.
People that have been in jail, Mr.
I was in prison for something 10 years ago, my first and only offense. He's had probation 7 times, never been held accountable. I take responsibility for my actions. I have come a long way, and I am a strong, good mother, and I am not going to let this keep happening.
We could do August the 4th, on July 30th, Friday.
And that comment just reiterates the fact that you need to recuse yourself.
July 30th or August 4th?
Yeah.
Do you have a preference?
Do you have a preference between those two, Ms. Toon?
Can you repeat the dates, please?
July 30th.
August 4th is a Wednesday.
August 4th.
July 30th is a Friday. Okay, probably August 4th is better with my schedule, Your Honor.
August 4th?
Yes.
You available August 4th, Ms. Toon? All right, we'll set the contempt matter back on August 4th.
2 o'clock.
2 o'clock, all right, 2 o'clock p.m. I will, I'll prepare that continuance order and again, ask that you provide Mr. Ward 2 weeks' notice of witnesses, and Mr. Ward, please provide your contact information as soon.
Absolutely, and I would just ask, at least here in open court, and she's a pro se litigant, that there are requirements under the rules of civil procedure that certain things. Here in open court, and she's a pro se litigant, that there are requirements under the rules of civil procedure that certain things that are done in this court be done in writing and notice be given to counsel. So anything in the future, please communicate with me. I will give you my information.
I guess I haven't been given that gift of a free attorney like, the criminals do, so I wouldn't know. I need to get a little bit better on my procedure.
Well, you may be entitled to an attorney here before much longer, Ms. Toon. I just became aware not too long ago that you have posted a recording of the previous proceeding on Facebook and then on YouTube. I would be shocked if that judge doesn't now charge you with contempt of court, and that time you'd be entitled.
I mean, he's threatened me 100 times before and belittled and degraded a lot of other women too, so I'll be that. I'll wait for a civil rights attorney. He's destroyed numerous lives.
All right, so August 4th on that matter. Anything else, Mr. Ward?
Not at this time, not at this
Anything
time.
else, Ms. Toon?
No, I just want that. I want it to be on record that I have included a document, a 50B, that was venue transferred and then buried in this courthouse and never actually heard, where my child was assaulted, and the Chief District Court Judge of Guilford County found that to be a fact, and due to Judge Miller handing her back while he was being arrested in the courtroom for violating our 50Bs, which were active, I get her back with a slap mark across her face. She had been assaulted and harmed, and then the venue gets transferred and it disappears. So everything that has happened to my child since then is on someone else's shoulders.
feel free to leave. You can return the phones once they get outside. What's that? Yeah. Mr. Ward, do you mind have your client just remain in the courtroom?
Yeah, sure. I need to give her my contact information anyway. So if you'll just sit tight here.
Remains off.
Sure.
Your Honor, may I approach?
Yes, ma'am. No, that's Ms. June, you're free to go. Oh, you're giving the contact info.
Address. Like I said, it's just something that if you have a question, we should just go over a regular review of what's set up and what's new.
This is only going to get bigger in the news.
What does that mean, ma'am?
It's going to get bigger until I can protect my baby.
You can come back up to the front, please. Is that some sort of threat to me about something you're
No,
going
I'm
to
just
post?
saying, the investigative reporter is talking to all these moms, and he's really looking into this. Like, all these kids are hurting. We can't protect our babies. What are we supposed to do?
I would just caution you certainly about posting anything derogatory about me or any other.
I have never posted anything derogatory about you whatsoever.
Posting a recording of the hearing on Facebook is highly inappropriate.
It's in an investigative hearing, an investigative reporter that did it, but if you've heard the hearing, you can see why it should be heard, because that was cruel and unusual.
You'll be dismissed once they clear the lobby.
Says the person that he's got multiple charges right now for assaulting another female officer, and I'm the one who's dangerous.
I'm not here to discuss your case.
I
I just want
know.
to make sure that and maintain security of the courtroom.
I'm tired of the games. I just want to be a mother.
Here, I'll say you sit down, and you'll be dismissed voluntarily. So,